All right, so we'll go ahead and call the meeting to order, regular meeting to order, and we'll start with the Pledge of Allegiance.
Chairman, may I ask you to check your mic, please?
Hello? Check, it's on. Nothing. Do you want me to just yell louder?
Check.
You
Check,
can
check mine.
Check. All right. We'll do that.
Switch mine since I'll be accusing myself.
Oh, we could do that, huh? Let me get comfy. Okay, so we will go to the. Can you hear me? Is it coming through now? No? Maybe. They'll lean right in. All right, we'll go to the first item on the list is the roll call.
Board Member Desportis?
Here.
Board Member Johns? Board Member Jones?
Here.
Board Member Fay?
Here.
Board Member Blazer?
Here.
Board Member Anderson? Board Member Bianchi?
Here.
Vice Chairman Munt?
Here.
Chairman Simon?
Here. Right, and with that, we're going to go to Elena for the adoption of the bylaws.
Evening, board members. By way of background, the Land Development Code was updated on September 21st, 2021. I thought this would be a good opportunity to make some technical changes just to conform those citations to our bylaws and to change, I think, the reference to Director of Planning to Planning Manager. So all the changes are technical, nothing substantive for your consideration. With that, available for questions.
All right, thank you. Are there any questions? With that, I will accept the motion.
Chairman, I'd like to make a motion to accept the modifications to the bylaws.
And we have a motion to approve. Do I have a second?
I'll second.
All right, we have a first and a second by Commissioner Fay. All those in favor?
Aye.
Anyone opposed? And the motion passes. They accept the bylaws as written. All right, with that, we're going to move into the public hearing. Non-consent public hearing items. Actually, you can jump.
I must recuse myself from this, Chairman. Thank you.
Right, so non-consent public hearing items will be heard at an individual public hearing and will be acted upon by the board by a separate motion. During the public hearings, anyone wishing to comment in support of or in opposition to the public hearing item may do so. If you wish to comment on a public hearing item, you must fill out a public comment form indicating the item number on which you wish to be heard. Once the hearing is closed, there will be no further public comment unless requested by the member of the board. With that, we will go. Josh is online, correct? So we're going to go to Josh with item number 3, AP 2102, the appeal of Meadowport setback variance. Josh?
We'll give it a few more minutes. If Josh can't reconnect, I'll present his case. Josh, are you available to present now?
I am. Thank you. Sorry about that.
Thank
The
you.
entire day I've been using the internet. It just crashed right now.
All right, you're up, Josh. Go ahead.
All right. Good evening. Thank you, Chairman and Board members. Tonight's hearing is an appeal of the town's zoning hearing officer's decision to deny V21-02 Meadowport, which was heard at a September 8th variance hearing. I'll run through the facts of the case as they were presented to the officer, and then present both staff's and the zoning hearing officer's findings. There we go. My apologies. This subject site for this evening's hearing is a 3-acre site located northwest of Cooper Guadalupe roads within the Fiesta Ranch development, and it's zoned light industrial with a planned area development overlay. In June of 1996, the town's design review board approved nearly 12,000 square feet of office and shop space on the site with potential future building pad north of the office space for potential future expansions. As you can see, I've highlighted the shop and office space on your screen. The year 2000, the former property owner constructed 2 additional structures on the site, which were then again further modified in 2006, which I've highlighted in red on your screen. These structures did not receive the required building permits, nor did they have any design review amendments, nor have any design review amendments been submitted since it was originally since its original approval in 2000. The former property owner submitted for a pre-application review with the town in 2015, and was subsequently informed by staff that the 2 unpermitted structures had not received design review approval and also were not permitted, and were also encroaching in the rear setback by up to 8.5 feet. And they would need to either move the structures or file for a variance. As staff's advice was not followed, a code compliance case was filed in August of 2019 and is still active today for those structures. I would like to note that once the new property owner took over the property, they've been working with the town this entire time. They have been trying to bring the site into compliance. Which brings us to the request tonight, and what was reviewed at the meeting last month was to reduce, it's a request for variance to reduce the rear building setback line when adjacent to the public facilities / institutional zoning district from the 15-foot requirement to 6.5 feet. Next, I'd like to move on to the findings of fact that are required to approve the variance and staff's review of the request. The first finding is that there are special circumstances of the property, including its size, shape, topography, location, or surroundings. In staff's review, we found that such special circumstances were not present. The 3-acre site is rectangular in shape and encumbered by size, shape, topography, location, or its surroundings. The site currently has nearly 64,000 square feet of buildable area within the building envelope in which structures can be built. All buildings approved on properties in the light industrial zoning district adjacent to the railroad, which is directly to the north, are required to adhere to the established setback of 15 feet. Now, staff has not found any structures located adjacent to the railroad and approved after 2005, which is when the LDC was adopted, that have been granted relief from the required building setback distance. Second required finding is that the circumstances leading to the need for a variance were not created by the owner. Now, staff can also not make this finding due to the issue created by the former property owner constructing the buildings without filing for the required permits. If they had submitted the building plans for review in 2000 and received approval, the structures would have been considered legal nonconforming, as the standard at the time of construction under the Unified Land Development Code was a 0-foot rear setback. However, because the structures were not lawfully constructed, they're subject to the standards at the time of permitting, which in this case is a 15-foot rear setback per the Land Development Code, which was, as I previously mentioned, adopted by the town in 2005. The third finding is that by granting the variance, it would not be considered a granting of special privileges to the property owner to have relief from a standard that other property owners have had to adhere to. As previously mentioned, we have not found any structures located adjacent to the railroad in the light industrial zoning district that have been granted relief from the required building setback distance. All structures legally built after the code changed in 2005 meet the code. There are a few structures that have a 0-foot setback, but those were approved before the code change in 2005. Everything after 2005 does meet that 15-foot setback. So staff finds that granting the variance would be a special privilege. The fourth and last finding is that the variance will not be materially detrimental to persons living or working in the vicinity. And we have no reason to believe that granting of this variance would be detrimental to the railroad or any adjacent property owners, or we find that we can't make that fact. So or we can make that fact. So we do think it meets the fourth finding. Now, at the September 8th variance hearing, the zoning hearing officers heard staff's at the applicant analysis of the variance request, and on September 16th, determined the applicant does not meet the first three findings of fact, and denied the variance for the reasons that are on the screen and were included in your packet today. So, in conclusion, both staff and the zoning hearing officer have determined the proposed variance does not meet all four findings of fact, and therefore we must recommend denial of V21-02 Meadowport. Now, we've put together four potential motions able to be considered by the board tonight. You may affirm the zoning hearing officer's decision, deny the variance request. You may reverse the decision and approve the variance, or you may reverse this decision and approve the variance with conditions. So we just wanted to put those together for you to help you out. So thank you for your time. I'll be happy to answer any questions you might have. The applicant's also here to present in person. They have a presentation for the board as well. Thank you.
All right. Thank you, Josh. Are there any questions for Josh, or should we go to the applicant? All right, Mr. Jarvis. You step to the podium. We'll give you 10 minutes initially to give us a presentation, if that's enough time.
Thank you very much. I've never had a problem being heard. I could be recorded on your microphones. My father was an elocution teacher before he was a lawyer, and made sure that we used our diaphragm when we were speaking. Anyway, am I being recorded now, or do I need to keep speaking from the diaphragm? In any event, we appreciate staff's work, but we do believe that the tests were met. And in fact, it should be noted, if you check the record in front of the hearing officer admitted that he came to that hearing intending to deny us, and that he took it under advisement because he was impressed with our case. We are not allowed to lobby a hearing officer any more than we're allowed to lobby you. At the end of that hearing, we had to leave. Staff was able to stay in the room. I have no idea what the conversation was after we left, but the fact is there was access we don't have. I would leave it to you to decide whether that's fair for the applicant, but we do have a very good case, and we made a good case to the hearing officer, and he said so. So let's talk about that case for a moment. Before I get into that, I want a little bit of background understood. This applicant is a family-owned operation. It's been in operation for 40 years. The owners live here in Gilbert. Last 15 years of this corporation have been spent here in Gilbert. They've been successful. They're expanding. This is a second location. The business is growing. $4 million in sales a year. That means lots of tax dollars for Gilbert, and it's expected to grow with this second location. Yes, the applicant was informed during the process of purchasing about this problem, and the applicant was told there are two things that need to be done: getting a variance and bringing the building up to fire code. As staff has indicated, the applicant's been working on them both. Let's click forward to about the third slide now. Staff tells you that there are not special circumstances here, but staff is overlooking the language of the ordinance in doing so. Special circumstances are applicable to property including size, shape, topography, location, or surroundings. This location is key to the justification of this variance, and it's key to finding special circumstances. It's an older industrial commerce park where the zero setback is common. Let me say that again, it's common. We're going to show you photos of it. Now, staff has said none of those were approved since 2005. But this is the location, this is the surroundings. Adjacent to an industrial railroad, as staff has indicated, they recognize there is no one to be benefited by this setback, and there is no impairment to anyone if this variance is granted. Not self-imposed. Staff says it was self-imposed because the previous owner built the structure without a permit. We're not seeking to get a variance from getting a permit. We're getting a permit. What we're seeking a variance from is the setback. And had they gotten a permit, had they applied for a permit, they would have gotten one because it met the requirement at the time. And that's why we say this is not self-imposed. Again, we are not seeking a variance from getting a permit. Staff points out that we wouldn't be here at all if they'd gotten a permit because we'd be illegal non-conforming use. That's true. But the variance is from the setback, and they met the setback when they built it. Variance does, staff has said that this grants special privileges. That's simply not true. Staff says it's a special privilege because no one's been approved since 2005 with less than a 15-foot setback. But that's ignoring the fact that there are a number of properties that have a zero setback in the area. This is not going to be a special privilege. It's been there for decades. Furthermore, staff has made no mention of any proof that there's been no structures granted relief who were permitted prior to 2005. There's been no investigation of that. It's just saying nobody's been approved since 2005. This is not a special privilege. It's a continuance of an operation that's been there for decades. And finally, we're all in agreement that the variance is not detrimental to anybody. Next slide, please. Okay. So this is what it looked like when it was built. There was a zero setback for the perimeter wall. Next slide, please. We're located along in an industrial park, LI zone, adjacent to the Southern Pacific Railroad, as you see there. Next slide. Originally, it was developed in 1998. That's where the 6-foot CMU wall was put along the property line. Next one. In 2000, these two partial buildings were constructed. Solid roof, 2 solid walls. And by the way, all we can really say for sure is that there is no permit of record. Staff has concluded that means they didn't obtain one. It wouldn't be the first time that records were incomplete. But we have to agree that there is no record of a permit. Next slide. At the time of construction, the construction code allowed for a 0-foot setback, as you can see right there. 0-foot rear setback. All right, now here's some photos of some other structures that are very, very close. Over there on the left, built between 1998 and 2000, 0-foot setback along that railroad line. And another one, built in 1979, portion of the building on the property line. And the next one, approximately a 6-foot setback, built about 2004. Built in 1998, the east building, 2004. So that's why we're saying this isn't a special privilege, this is an existing condition. We are not seeking a variance from getting a permit. We are getting a permit for it. In 2006, the roof was removed. The walls remained in place, so they were still there within the setback. 2011, roof was reconstructed and the eastern portion was enclosed. Of course, this is after the law had been changed, and there you go on the next slide. We have the 15-foot setback that was put in place in 2005. I've already dealt with this. So I won't rehash it, but this is how the tests were met. We do believe there are special circumstances because that includes location of surroundings. We do not believe it was self-imposed because we're not seeking a variance from getting a permit. We are seeking a variance from the setback, and it met the setback at the time. No special privileges. We've talked about that. There's other uses in the area that have the same kind of condition. Not detrimental. We've already agreed to that with staff. So in our view, all of the tests are met, and we would suggest to you that there's a reason that you have this power. We are talking about existing buildings that have been existing for a long time, setting back from a railroad line. This bothers no one. There is no complaint. There is no problem here. And you can find that the tests have been met and not create some sort of a precedent of ignoring the law. Now, I have Mr. Rick Thornock here of Metro Fire. He'd like to say a couple things very briefly, if that would be all right. Thank you.
Please state your name and address, please.
Rick Thornock, 63 South Hamilton Place, Gilbert, Arizona 85233. Thank you, Mr. Jarvis. I did want to correct one thing on the PowerPoint. Metro Fire's annual sales is $40 million, not 4. I think I provided a typo, so I want to make sure on the record that that's not inaccurate. First off, just want to say thank you. The week of Thanksgiving to be here. I'm sure you'd rather be doing other things. And also just kind of add that the decision here has real economic impact. I know you have to look at the 4 prongs that Mr. Jarvis has presented on, provided a potential legal hook for you, but practically speaking, if you rule against Metro, the buildings have to be raised and then either rebuilt or something else happens. So we're looking at $100,000, if not double cost. That seems to be economic waste, really, without much purpose. It's been there for over a decade, not really bothering many people. Also, as staff talked about, in 2015 was when the first petition happened, and then 2019 is when the case was opened. So why the 4-year discrepancy? In 2018, the fire marshal came through and determined that those back buildings needed to have a fire riser and fire sprinkler. And so that's the owner at the time started a petition for that. And when we, Metro Fire, purchased the building, that was kind of it was told to us, hey, these back buildings have to have fire sprinklers. So we thought this is a perfect situation. We can go in, do it ourselves, make sure everything's protected. And so we actually went down the process. We're working with staff on what the requirements are, where the sprinklers need to go, and then halfway through that process of design review, it came back and said, well, actually, these buildings need to be destroyed anyway. So it's just kind of a little bit of frustration on our side, but our intention is to comply. We love working in Gilbert. We have 61 employees who live in the town of Gilbert, and again, the owners live here, so our intention is to be good residents, be good neighbors, and hopefully you'll find that the prongs are met, and then we can proceed. So thank you for your time. Appreciate your time coming tonight. Thank you.
All right. Thank you very much. And I don't see that we have any community members. All right. Does anybody have any questions for either the applicant or staff? Mr. Bianchi.
Okay. I guess for the applicant. So, Mr. Jarvis, when was the property purchased? When did your client purchase it? 2020.
For the record, 2020.
Okay. Did they disclose to you that there were active or open code compliance cases against it at the time of purchase?
So, yes, and in legal language, they said you have to have everything resolved. It was kind of presented to us that it was the fire sprinkler issue, which is why we went down.
I'm going to need
Yeah,
that.
she's going to ask you to go to the
Yes.
mic.
Have you step up to the mic,
I guess
please.
we can hear you, but
Yeah. We just need to get it on recording.
I'll just stand here. So, yes, it was disclosed that, hey, there are some zoning issues, but it was presented as it's the fire sprinkler issue, and that's when we purchased. We were halfway through the process of working with town design to get a permit for the fire sprinklers and fire riser when it came out, well, actually, these buildings need to be destroyed. So that was how it played out.
okay. And then so we went through multiple, I don't think my mic's working either, but we went through multiple modifications to these buildings. So no permits were ever filed through any of those modifications, whether it was 2000, 2006, or...
So far as we know, no permits were.
Okay. So really, we don't know if the buildings constructed would be issued permits today as constructed or modified to see if they were detrimental, if they were never reviewed.
Well, actually, that's part of the process that we'd be going through now, is making sure that they meet all the structural requirements, fire safety requirements. That we're not seeking a variance from that at all.
Yeah, right. Okay, thank you.
Anybody else? Mr. Fay?
Yeah, I think you partly answered my question, but I'm still kind of confused in the process of purchasing the property. Whether this is counted space would have shown up on the property tax rolls. I mean, all of that. Did that not show up anywhere, or was this inappropriately classified? Were these buildings inappropriately classified?
I don't know the answer to that.
Staff? Josh, are you still there?
Chairman, I am still here.
Do you know the answer to that question?
Could you repeat the question, please?
Usually you look at the square footage based on either property tax or the county recorders, and usually that's based on the permitted structures. I'm surprised this wouldn't have entirely unpermitted structures should have jumped off the page when you're buying a piece of property. I'd be surprised that there wasn't. If it is recorded, then are you sure there wasn't a permit? If it is recorded, or if it isn't recorded, then it would seem kind of obvious. Do you know if this is on the property tax rolls? Is this on the Alta survey? Any of that kind of stuff?
Chairman, board members, I don't know. We haven't been provided with an Alta.
Okay.
I don't know.
Okay, no problem.
Chairman?
Yes.
From what I've heard, that throughout the violation case, there was never anything said by the owner that these were permitted structure. It was at that time when code enforcement sent out the violation. I believe it was agreed that these were unpermitted. Nobody ever argued that they were permitted and that the permit was lost.
Okay. Any other questions? I just have one. Mr. Jarvis, you had mentioned, I think you had a slide in there. Obviously, you had multiple pictures, but one of the slides you had was the setback at the time and that there would not have been a variance at that point in time. Did I catch that correctly?
That's correct.
Can you go back to that slide?
Right there.
I don't know if I can see that.
Zero setback on the rear.
Right. So I see that. I was just looking for a date on it to confirm. I mean, not that I would.
This was the ordinance.
It was,
prior
okay.
To 2000.
Okay. Yeah, Mr. Jones.
Can I ask a question? Mr. Jarvis, you showed that there are some other examples of these 0-foot setbacks in the nearby area. Can you speak a little bit more to kind of proximity to the site here?
I'm going to ask Michelle Santoro to talk about that. She put that slide together.
I believe they're all within the same complex.
Yeah.
Michelle Santoro on Crowley 3101 North Central. They're all within the same development, industrial development. Most of them just northwest of the site.
All right. Anybody else? Any other questions? Okay.
Thank you very much.
Thank you very much. I will bring it back up for discussion. Anybody want to jump in first? And Mr. Blazer.
So, I don't know if you can hear me, but I'm going to talk. So I have a couple of thoughts. And I think it all speaks to whether or not we would change the finding of facts, right? So that's the context by which I would offer my thoughts. If we were to see this as a zoning case and they requested a variance through a zoning process, it would be a no-brainer for me, right? So I would probably grant it, especially with the neighboring properties having the 0-foot setback. I appreciate the take on not seeking a variance for permit, that the proper steps are going to be taken. So I'm trying to be reasonable to see if our take on the property would cause us to change the finding of facts. I like the question about the Alta survey and the taxable square footage. It seems like you would get a pretty sweet deal on the property if an appraiser came in and knew that those were not permitted, and therefore spending some money to modify that and get it within code, I don't think would be an unreasonable request by the city or an unreasonable expectation. But I'm sensitive to the fact that that it's a new property owner. So those are my thoughts. I just want to make sure if we deliberate or have a discussion that we that we're reasonable in our approach. And anyway, those are my thoughts.
All right. Thank you. Anybody else? Mr. Bianchi?
Sure. In regards to reviewing for the four findings, I sympathize with the client and the applicant, and when you take this and you're doing your due diligence and things like that. But in review of the four findings, I see that 3 of the 4 are not met. I do believe the 4th is it will not be materially detrimental. I don't find that to be an issue, especially with the railroad behind it. But the other 3, as far as special circumstances or being created by the applicant and owner and whatever happened with the previous applicant. And I do think if we do it, we are granting a special privilege because we're going through this process without permits, without knowing what the history on it is to review. So the way I would lean is that at least 3 of the 4 findings are not being met.
All right. Anybody else? All right. Not seeing any. I kind of agree. I mean, I go back and forth because I'm very compassionate toward the position that you're in, and I feel like if this was a zoning case, I'm looking at the railroad and I'm thinking, well, if the railroad doesn't have issue with you backing up or abutting their line, why would we? Keeping it in the purview or the context of where we sit today with these 4 findings of fact, I'd probably even look at, such special circumstances were not created by the owner or the applicant. I don't know that you created this, so I don't know that is factual. So I'm thinking, maybe there's 2. Yeah, I don't know. I'm open for a motion if somebody would like to make a motion, but I'm. Either way, and as Josh mentioned, we basically could take as they say it one of 3 motions. We can affirm the findings of fact. We can reverse the findings of fact and approve the variance in this situation, or we can reverse and approve with changes to it. Anybody want to take a shot at it?
I'll go ahead and take a shot.
Okay, Commissioner Bianchi.
So I would move to affirm the zoning hearing officer's decision and then able to make the findings and deny case V 21-02.
All right, we have a motion to approve the findings of fact by Mr. Bianchi. Do I have a second?
I will second his motion.
And we have a second by Mr. Fay. All those in favor?
Aye.
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 Any opposed?
Nay.
Nay. So we have, what is that, 4-2? And it stands. Do we need to take a roll call?
Approve or affirm?
Chairman, just to confirm, the consenting vote was Board Member Blazer?
And myself.
Yes.
And yourself. Okay, so there were 2 opposed. Chairman Simon, Board Member Blazer. The remaining 4 were in favor.
Correct. In favor of approving the findings of fact and denying the request. All right. items of business on the agenda, so we'll go ahead and adjourn. We'll go ahead and adjourn.
I do have an administrator. Do we have to type something up now, or you'll do? Based
Yes,
on our
the
comments
the
here?
minutes of the meeting will serve as the written documentation. Thank you.
Like weed out some of my irreverent comments that I made along the way.